Good morning and welcome. Today we're going to be talking about fraud, corruption, and collusion, and defending companies at the World Bank Sanctions System. And those are the offenses or the charges that companies will face in front of the World Bank system. And so we look forward to covering that and many other things. We have an excellent panel joining us today. Matt Ellis is a partner at Miller & Chevalier. He runs our Latin American group. He also is a former investigator with the World Bank, and he's going to have a lot of helpful information from both sides of these proceedings to talk about today. Antonin Levy is the founding partner of Levy & Associates in Paris, and he also has a host of experience in white-collar practice, but in particular defending companies before the World Bank Sanctions System and before other multilateral development bank systems. And so with that, we're going to get started. But before we do, we did want to remind you that if you have any questions, you should send them to events@milchev.com. So that is the email box on the screen at this point. Send your questions there. We will respond to them in the course of the proceedings. And with that, let's get started. And I'll turn it over to Matt to just talk generally about the process, and we can talk about some of the trends in front of the World Bank Sanctions Board and some of the other multilateral development banks.
Great, Tim, thank you. And it is great doing this webinar with both you and Antonin. You know, this is an area that is near and dear to my heart, as you mentioned, Tim, having worked at the Integrity Vice Presidency and at the Inter-American Development Bank's Office of Institutional Integrity, you know, having worked with some very smart lawyers and accountants and investigators from those units. And now defending companies before sanctions proceedings. You know, this is an area of importance. And one reason I think this webinar is so important is because there is such a need for education in this area. It is, as we will be discussing on this webinar, it is very common for companies to be surprised when they're wrapped into a series of multilateral development bank investigations. You know, they might be surprised by you know, the burdens of proof associated, the statute of limitations associated with these, and it might, you know, oftentimes it's too late when they finally reach out to legal counsel for assistance. And so, you know, the more we can get out there and educate companies on steps to take to successfully engage in these very important initiatives while at the same time protecting themselves, I think that is worthwhile. Antonin, it's a pleasure working with you on this as well. I know you have a vast amount of experience in this area. Perhaps if you'd like to say a few introductory words, and then Tim, we can move to the first slide.
Thank you, Matt. It's a pleasure being here. Indeed, it's important to share, I think, our mutual experience in this field. And it's true that fraud, corruption, and collusion procedures with MDBs are very, very specific procedures to which companies are unfortunately not enough prepared. And we see that in this very specific area of law, there's a lot that we can do to anticipate and to make sure that the investigation will go as smoothly as possible.
And just starting out and kicking it off, you know, I guess the first point I would make is when you consider the amount of commercial activity connected to projects that are financed by multilateral development banks. You know, here are some statistics just from the World Bank itself. It's not a surprise that corruption, fraud, collusion can arise. You know, you add to the picture the fact that the missions of these organizations is to alleviate poverty and to contribute towards shared prosperity. And so these projects, you know, most often play out in parts of the world that are considered higher risk for corruption and other prohibited practices. And so, you know, it is not a surprise that there is significant risk for companies and individuals when engaging in this type of work.
And Matt, you raise a good point on that. And my understanding is that we're seeing recently as these boards tend to become more developed, we're seeing more charges being filed and more charges being filed against larger and larger companies in these areas. Is that right?
It certainly is. I mean, there is a specific focus on the bigger fish, on the higher impact cases, and what the World Bank is doing, the Inter-American Development Bank, perhaps others. And just to stop for a second, between Tim, myself, and Antonine, we have experience in sanctions proceedings in almost every one of the multilateral development banks listed here on this slide. But it's those higher impact cases that allows the banks to create the deterrent effect, to send a message on compliance expectations, and to make a bigger impact in terms of tampering down misconduct in the context of these projects. So yes, that is certainly a trend. It's something you will hear from the investigators themselves. There are even sophisticated filtering mechanisms being set up by these investigative units to monitor the press in higher risk jurisdiction, to catch instances where companies that might be participating in bank finance project, companies that might be caught up in investigative webs and other scenarios, capturing that information and acting upon it.
And Antonin, I know that you recently had an experience with one of the bank proceedings where it became clear to you that the investigators were trying to make a point, regardless of kind of the facts in front of them, that they had something that they wanted to send a message to a larger community. Can you talk a little bit about that?
Yeah, of course. We've recently been facing a situation where, in the experience you have of negotiation, we were dealing with corruption of a bank employee, alleged facts of corruption of a bank employee. And the situation we had to face with that, regardless all the excellent arguments we have in defense and all the elements that we could present in terms of compliance program, enhancement in the compliance management system, change in the management, the bank was wanted to make a statement that alleged corruption of its own personnel were the most serious circumstances that they would not be negotiating with. And we're dealing with a situation where normally those cases tend to go to resolution, and you're dealing with a body in front of you that is telling you that for those specific facts, they're considering non-negotiation and going straight to litigation, which is basically them making a statement and trying to tell everyone that internal corruption will be an issue they won't negotiate with.
Interesting. Well, why don't we turn now to some of the processes. Why don't we turn now to some of the processes and procedures at the World Bank, and start from a general overview as to.
Tim, we've lost you. There you go.
Yeah, no, I'm somehow getting muted when I try to switch the slides. So let's start back on the slide with harmonized approaches and talk about the general World Bank process and the multilateral bank process, and then we'll go to the specific World Bank process.
So I can jump in here. These banks have made important efforts over the last 15 or so years to establish systems that carry legitimacy. And one main reason of doing that, one main way of doing that is creating independent investigative units and then multi-tiered sanctions processes, where perhaps a determination at the first level review can be appealed and reconsidered at the sanctions board or sanctions committee level. Another step that the banks have taken has been considerable efforts to harmonize their approaches. So you have in 2006 the guidelines for sanctions that outline ranges and types of penalties and the types of evidence and findings that the authorities will consider as aggravating and mitigating circumstances with respect to penalty calculation. You have harmonized definitions of prohibited practices like corruption, fraud, collusion, coercion. You have shared commitments to exchanging information. You have shared commitments to integrity due diligence. You have, perhaps most notably, is the agreement on mutual enforcement of debarment decisions, cross-debarment. This was a development in 2010 that served to add teeth, to add a bigger bite to the sanctions debarment process. The fact that now if one bank debars an entity, if that debarment period is more than 1 year, that entity will automatically be debarred by the other multilateral development banks. And then finally, you have efforts to coordinate how the banks will treat corporate groups. You know, there are a lot of important questions when a sanction is applied. Is it applied to a parent company? If a company receives a sanction, after receiving the sanction, the company is acquired, what happens? So there have been coordinated efforts there.
Very helpful. It sounds like there are coordinated efforts among the multi-development banks, but also coordinated efforts with the national enforcement authorities. And I think both of those are very important. Antonin, do you want to talk a little bit about kind of how that plays out, where if you are defending, you know, what is a civil proceeding in front of a multilateral bank investigation, that those same facts could wind up being forwarded over to national authorities in France, and then we'll let Matt talk about that, how that works in the US.
Yes, Tim, of course. It's when you're dealing with those type of investigations, you have to be prepared to deal with the consequences of the primary MDB investigation. And what happens a lot is that your proceeding with the MDB will end up in ancillary proceeding with the big criminal or civil in your home jurisdiction. There are two ways for that to happen. The first one is that the MDB can transmit and forward the conclusions they reached in the investigation to local prosecutors. For example, right now in France, as we speak, the World Bank is negotiating a framework agreement with the financial prosecutor in order to create a negotiation framework for the World Bank to discuss with local authorities. What we have to realize when we're talking about MDB procedures is that those banks are not states. You know, they are entities, of course publicly funded, but they are not states, and so they don't fall within the typical frameworks of international cooperation. And so either they forward just by regular post or mail the elements they have to local authorities and create new criminal procedures, or as it is the case in France, they now create large negotiation frameworks in order to become a central key in the criminal enforcement in local countries. And that's extremely interesting because you can see how you can have difficulties created. Just one example, Tim, you know that MDBs can offer immunity deals to individuals, and they can offer to a key player in a company immunity against its own testimony. The way you see that playing, for example, in France, is that France doesn't know immunity deals. So if you end up in front of a prosecutor and you confess everything against immunity from sanction against the World Bank, well, that's just admitting to committing a crime. And obviously, when this gets forwarded to national prosecutor, it has to be considered carefully, because the negotiated immunity, that's very good. What you might end up doing is continuing working on large-scale projects, but directly from your jail, because just local and law enforcement will not take your immunity deal for granted and will prosecute afterwards.
So the immunized statement, if I'm understanding, that you give to the World Bank or to one of the multinational development banks can then be forwarded to prosecutors, and it's no longer immunized. Is that also a problem in the US in terms of the coordination, Matt?
Yeah, it certainly is. It's a good point. I mean, you know, it comes into play in a number of different ways. If a company, as Antonin says, is engaged in a negotiated settlement, it has to realize that the information what it's admitting to it can be shared. It can turn into a criminal referral, and we see deep coordination and cooperation between authorities at the multilateral development banks and the U.S. Department of Justice, as well as in other jurisdictions. You know, a case, and perhaps the first case where this became apparent through public records, public reporting, was the SNC Lavalin case, one of Canada, the Canadian authorities' first big anti-corruption initiatives. And that was begun when the World Bank had found evidence that a bribe would be paid. And the issue was not yet ripe for purposes of the World Bank's own sanction system. And so it referred the information to the Canadian authorities who wound up taking action. This related to a bridge project, the famous Padma Bridge project in Bangladesh. And another component of that case, which was interesting, was that, you know, the World Bank did something that national authorities can't do, which is withheld loans to Bangladesh until Bangladesh took a serious approach itself to investigating the matter. And the World Bank even set up a committee of experts to monitor the Bangladeshi investigated efforts. So, you know, in some ways, the banks have tools or leverage that national authorities do not have. And it's also important to highlight that the cooperation runs in the other direction. That we have instances where DOJ and national authorities share information, you know, come across MDB finance projects and wrongdoing, and they share that with the banks themselves. So, you know, there are a lot of different, and then finally, we have instances of joint operations, you know, DOJ inviting World Bank investigators to participate in interviews, et cetera. So there is a lot going on behind the scenes that perhaps a company or a business person is not attuned to. We already on this webinar had a question come in from Argentina on this very issue, and the response is definitively yes. There is cooperation, and respondents should assume that evidence collected by the banks can get into the hands of national authorities.
So it sounds like, Matt, that these investigations can have huge consequences, not only with respect to the ability to get further development projects, but they can have criminal and other serious civil consequences on the national level. So it's important, I would think, to really understand that as soon as this process gets underway, that a company or an individual who is contacted by that process ought to take it seriously. So
we lost you, Tim.
all right, why don't we talk a little bit then about the World Bank sanctions procedures, so that people can understand how to get started on those procedures from the earliest stage. Why don't you talk about how they begin, Matt, and then where they go after the process begins?
Sure. And what we've done here for the audience is we've tried to compare two of the MDBs. First, focusing on the World Bank and its procedures, and then focusing on the Inter-American Development Bank and its procedures, so we can compare and contrast. Antonine, perhaps you can start us off here with the World Bank sanctions procedures. Another thing we've done is we've injected some data to give the audience a sense of, you know, what type of frequency of activity, what volume of activity, investigative activity is out there.
Sure. So as you see, and as Matt was saying before, you have a several steps process in the World Bank sanctions procedure. So the first body you're going to be dealing with is the INT, Integrity Vice Presidency, which is a part of the World Bank Group, independent from the investment team and directly linked to the president of the World Bank Group. And the INT will be the body in charge of investigating complaints, issuing the show cause notices to respondents, basically starting the procedures and they will be the one investigating. So inside the INT, you will have the investigators, the legal team, the accountants, the forensic specialists. They will be the one going on the ground and proceeding to interviews, auditing your documents, reviewing your emails, interviewing your employees, and sending you emails all day and night long in order to get more information to complete their investigations. There will be the people you will be spending 18 months of your life in case you have an investigation that will be starting. And Matt can probably give us more examples, but they have multiple backgrounds. Some of them are previous lawyers, former policemen, you have people from the army, people from Big Four accounting firms, and there are very diverse nationalities and backgrounds in those teams.
Yeah, I mean, Anthony, just to jump in there, because I do think this point is an important one. It's a stylistic consideration, right? And so you're dealing with very competent investigators, lawyers, accountants, as you say, from different jurisdictions, but they all come from different backgrounds and practices on how to build cases, investigate cases, prosecute cases. And so, you know, some are from adversarial systems, some are not. So what it does mean is that for practitioners who are engaging these investigators, you know, there are elements of flexibility that are required to do so successfully.
And I also did want to jump in on one of the points that Antonin made about the amount of time that this process can take. I mean, my understanding is that once you learn that there's an investigation, it can take months, and I think you mentioned 18 months and even years to get to even the stage where a charge is brought. Can you both talk a little bit more about how long this process can take?
So there is no specific stated limit on the investigation phase, on the timing, the duration of it. And they can be, especially when the investigation involves a degree of complexity, investigations can take literally years. And this is something, you know, to the extent we have any of our clients on the webinar who have dealt with this in the past, they might be chuckling right now, because it is an element that can generate extreme frustration for companies and individuals responding to these inquiries. So that is an element that, you know, I think as practitioners, we have to condition our clients to anticipate the long delays in time.
Indeed. And so coming back to the World Bank, if you deal with INT, there are three ways this is going to end. The first one is after investigation, there is no sanction that can be taken because there is no fraud that has been committed. That's the best case scenario. Option two is you reach a settlement with the INT, so that the NRA, the negotiated resolution agreement, that will terminate the proceeding with an agreement and close the book of this investigation. If, however, none of those two scenarios are reached, then the matter is escalated to the next step, which is the OSD. So the OSD is the first sanction system where you will have to advocate your case based on an investigation that will be at this stage completed. And again, there is a dual level system, and if you are unhappy with the decision of the OSD, then you get to the sanctions board, which is the ultimate appellate body that will finally determine if a sanction has to be taken against your client. So obviously, as you can imagine, we're coming to a case where most matters get settled in NRAs. A limited number of them will go in front of the OSD, and the OSD will determine if there's a sanction, and a more limited number of cases after OSD will finally go to the sanctions board.
One quick question for Matt here on that process. I notice on the slide there's a discussion of temporary suspension. And so can you talk a little bit about when that comes into play and how that works?
Yeah, and this is a provocative topic. During the investigation, if the investigators do perceive continued engagement of a specific entity as creating risk, they work with OSD to apply the temporary suspension. Now, from a legal perspective, it's a situation where presumption of innocence does not apply, right? So the temporary suspension is applied even before a formal accusation of the company is made. But it's the bank's way of protecting itself in these long, drawn out proceedings. A respondent can find itself temporarily suspended for years, and before the sanctions board prevail in lifting not only the temporary suspension, but putting aside the sought after debarment. So it is a unique aspect of another point I wanted to make with respect to the sanctions board is really honing in on the fact that the board reviews these cases de novo. It reviews the entire record. The board is a collection of Tim, I know you know this, very smart, well-prepared legal scholars, right? And they take their job extremely seriously. They do not give deference to the earlier decisions by the OSD. What this also means is there can be a situation where a company decides to appeal and the sanction board applies a penalty that's even more onerous, perhaps a debarment period that's longer than the OSD was recommending. So it is a bit of a risk or a roll the die for some companies in some circumstances and some fact patterns to appeal up to the sanctions board.
Yeah, I will say as a practitioner, mostly in the US courts, both at the trial and the appellate level, it's really an interesting process when you're up at the sanctions board because you have judges, but you're at essentially the de novo trial level. And so you have a panel of 7 judges, which is akin to a US appellate argument. But on the other hand, they are fact-finding judges who are extremely prepared and really, at least in my experience, have looked very closely at the facts. So it's kind of a mix from a U.S. perspective of an appellate proceeding with a trial proceeding, and it's quite an experience. So why don't we move on? Why don't we move on to some of the trends in front of the World Bank and talk a little bit about some of the data in terms of their cases.
Yeah, and perhaps I can walk us through this, and Anthony, please feel free to jump in. This is the data that the World Bank publishes on its cases. And so since 2007, you see that 29% of respondents choose to contest the proceedings. And in 38% of those cases, the sanctions were reduced by OSD at the first level of review based on the arguments by the respondents. So what this tells us is, it can make sense for a company to choose to make the investment and take the time to challenge the accusations that are made. And then when you move to the sanctions board, this data point shows that 16% of the cases before the sanctions board in this period of time since 2015, 16% the board found no liability. Now, what this data point doesn't tell is that in some of those cases, and we've experienced this firsthand, what a respondent can do is reduce debarment down to a non-public letter of reprimand. So that would still be captured in the 84% here, but I can guarantee you it would be seen as a success by the respondent to put the issue behind itself. And then in 2019, this gives you a sense of the volume of cases, significant amount of investigations. What INT does when it receives a complaint, and it does its preliminary work to see if they're there to proceed. And of the 47 investigations is completed, more than 3/4 it found were substantiated. You have data here on temporary suspensions. Also, you have data on the integrity compliance officer. So we'll be talking about the type of penalties, the type of results that can apply, and the baseline sanction is debarment with conditional release. So conditional release essentially means that a company can lift the debarment after the period has run only if it can show certain things have happened, one of which is that it has adopted a compliance program that meets the World Bank standard, and that evaluation is made by the integrity compliance officer. And here you can see that that individual is busy or was busy in 2019.
Very busy. Antonin, do you have anything to add in terms of the stats, or should we move on to the to the Inter-American Development Bank?
Just one point, and we talked about that before, but we can see that 42 referrals to other authorities is an important figure, and it does not take into account the cases which are opened by local prosecutors, not based on referrals, based on press articles or based on whistleblowers. So it's important to keep in mind that a number of MDB's investigation will turn into local procedures.
Yeah, and I think it's just another example of the fact that it's INT making these referrals, and so you've got to get started as early as possible in the process.
Good point. So moving to the Inter-American Development Bank, you know, and talking about referrals, Antonin, it's not only the World Bank, as we know, it's each one of the multilateral development banks has this ability and interest in sharing evidence collected. So that just proliferates the risk for companies. At IDB, to summarize the procedures, in many ways, they are similar to the World Bank. You have the investigative phase, you have the first level of review, in this case it's called a sanctions officer, and then you have the sanctions committee. There are nuanced differences that are important to highlight. This is one reason why it's important to engage competent counsel that knows that, you know, not every MDB is made the same. This here at the Inter-American Development Bank, a couple of things to highlight is when OII, the investigative authority, is investigating, you know, to the extent a company wants to consider a resolution, it can only happen during the investigative phase at the IDB. As soon as OII issues its statement of charges to the sanctions officer, that ability to reach a negotiated settlement goes away. That is unlike the World Bank system where negotiated resolutions can be consummated up until the very end. Another important distinction to make is that here, the sanctions officer of the IDB receives the statement of charges. There's always some back and forth, and we have this at the World Bank as well, between the first level of review and the investigators, perhaps clarifying certain issues, perhaps pushing back, forcing the investigators to, you know, go find more evidence or build a stronger case or simply take out a charge that is not as strong as it could be. But after that, in the case of the IDB, the sanctions officer then reaches out to the respondent and gives the respondent the opportunity to respond before making his determination. So some might argue that there's a bit more, I don't want to use the word fairness, but a bit greater opportunity for a respondent to shape the outcome at the IDB. In contrast, at the World Bank, the evaluation officer there reviews INT's charges, reaches a determination on debarment period, informs the respondent of that determination, and then the respondent is given the opportunity to make its argument. So that's an important distinction as well. Up until recently at the Inter-American Development Bank, these decisions were not published, which made it a bit harder than at the World Bank, to its credit, you know, striving for a level of transparency and publishing in a significantly detailed way its decisions, the reasons, the rationale for the findings. That has now started at the IDB, which I think is a helpful element of transparency. But those are some of the nuanced distinctions that one finds among the different multilateral development banks.
Great. Why don't we talk a little bit about some of the trends at this point in terms of the IDB. Again, I think, Matt, your point about the fact that you can shape the proceedings, again, talks about the need for getting involved early in these cases, but it looks like some of the stats make that point as well.
Yeah, and here you see from this data, this is from 2018, published in the IDB's annual report, that, it can be worthwhile to contest an OII accusation. There are cases where the sanctions officer dismisses cases based on new evidence shown. Out of the, as you see there, it's the sanctions officer issued 33 sanctions determinations. To give you a sense of the bite, about half of those, 15, had a sanction of, I think it's between 4 and 7 years, so of debarment. About 9 of those had a sanction of between, 3 years or less. So that gives you a sense of the considerable consequences that can flow from this type of conduct and inadequate defense. Finally, the very final point, and picking up on Antonin's prior important points, and picking up on the point of cross-debarment, in 2018 alone, the IDB recognized 131 sanctions that were imposed by other multilateral development banks. So again, this gives you a sense of the amount of the number of companies that are caught up in these types of matters every year.
And Antonin, if you wouldn't mind just kind of giving a little background to talk about some of the similarities and differences between the European Development Bank and also the African Development Banks, because I know those are 2 areas in which you've had a lot of experience.
Of course, the process is indeed quite similar, and mainly it's the name of the bodies that will change. So for example, with the AIB, you'll be dealing with, that's European name, so it's quite complex for exactly the same thing. Inspectorate General Fraud Investigation Division, which we call IGIN, and with the AFDB, you'll have the IACD, so it's always Integrity and Anti-Corruption Department. And you'll see the same structure, which is being reflected. What's interesting compared to what we were saying before is that you definitely see that those MDBs are talking to each other. So of course, through the cross-debarment that Matt was referring to, but also when you're handling cases with one of the banks, they can, for example, step in after a first bank initiated the sanction procedure. So for example, if you're going to have a project that is multi-funded and you will have 2 banks inside, the EIB will, for example, let the World Bank lead the investigation, take the sanction, and then come in a second pass to negotiate again with the company. And that can be troubling, obviously, for a company who thinks they are done with investigations and will see a new bank knocking at the door. You also see those interactions with the fact that their legal doctrine are quoted internally. So for example, we have a case with the AFDB right now where they are presenting to us the internal legal doctrine of the World Bank to justify their decision, just because in fact the World Bank might be a little bit more advanced in setting the legal doctrine and in creating the legal pattern. But you definitely see the fact that those banks are talking together, getting their system harmonized, and they're trying to create one sanction system among them.
Very interesting. So it does sound like there's increased coordination among these banks. Why don't we talk about who winds up in front of these banks? So why don't we talk about the companies that wind up as respondents in some of these bank proceedings related to some bank finance projects?
So I can jump in here, Tim. First, if you're a company that participates in MDB finance projects, if you're an individual working for one of those companies or owning one of those companies, you should be aware of the risks and the compliance expectations. One thing that often surprises companies, and we see effort after effort by respondents to challenge this determination unsuccessfully, is that A company does not need to win a contract in order to be subject to a sanction. It simply needs to participate in the pure procurement process. It's in the bidding documents, it's in the procurement guidelines, and the consultant guidelines that are referenced in bidding documents. You know, that's where the sanctionable practices are defined, and that's where the integrity standards are laid out. And so, you know, anyone participating in these processes can be held responsible before the sanction system for fraud, corruption, collusion, et cetera, even if they did not win. Now, what is the bank's justification for this approach? What they say is, by mere fact that you are participating in our process and you are engaging in fraud, corruption, you were damaging the integrity of the process, and that's a sanctionable offense. Another thing to highlight, which again is a source of great frustration among companies and respondents, is that even if a company were to win the contract and perform the contract successfully, you know, they built the water system in Tajikistan and it's the best water system and it's working perfectly. Even in a situation like that, if there's evidence of misrepresentation, for example, in the company's qualifications and in its bid, that is a sanctionable offense. It's an area of huge frustration, but it's a reality in the overall system that needs to be considered.
That's definitely something that you hear over and over again. As a company completes a project, does it under budget, and these sorts of investigations can come back years later after what they had viewed as a successful project. Antonin, any discussion about how long these cases take? I know we talked about how long the investigations can take, but these cases often look back how long? 4, 5, 10 years? How long do your cases go back?
It usually depends on the complexity of the case. Overall, until you hear no more from the multilateral development bank, it takes quite a long time. First of all, you have the investigation phase, which itself is lengthy and can take 18 months, 2 years, 2.5 years, 3 years, sometimes just making document reviews, interviews, and completing the fact-gathering process. Then, if you want to engage into discussions to reach a negotiated resolution, there will be an extensive period of time negotiating with, for example, the IMT, with the World Bank, trying to reach a fair settlement, which again will take 6 months, 12 months. And once you reach this agreement, as Matt was saying, you can have a conditional non-debarment in full or in part, and this will also create a new time period upon the company during which the ICO for the World Bank will supervise the management system of the company, and the debarment control will also be set by the agreement. So overall, if you put every piece together, it can be, including the control of the ICO over the compliance management system, 5, 6, or 7 years dealing with parts of the multilateral bank. And it's very, very, very long investigations overall to be considered. So when you receive the letter, the notice letter, the first letter from the bank, it's just the very start of a long process that you have to handle.
Interesting. So we've talked in the title about what types of conduct that the World Bank or the development banks are looking for. But let's dig down a little bit deeper. We know that it's fraud, corruption, or collusion, potentially coercion, potentially obstruction. But why don't we talk a little bit about kind of what these practices are, and I think more importantly, how these banks look at these practices, because I think they're very different from the way that white-collar practitioners and practitioners in particular state and federal proceedings are used to defending or defining these terms.
Yeah, I'll start off, and Tim, I know you have thoughts. We've done a lot of work on these issues and crafting defense strategies for companies, but you know, I think from a high-level perspective, you have to understand the context, and the context is the following: these are banks. These aren't sovereign authorities, right? They're banks who recognize that their ability to collect evidence, their powers to compel, et cetera. They don't have the ability to subpoena documents, for example. Their hands in many ways are tied in the investigative phase. And so in the design of the sanctions system, including the definition or interpretation of elements of the prohibited conduct, they take, aggressive and broad approaches. And that is seen in, how corrupt practice or fraudulent practice is seen. I like to describe fraud in the context of MDBs as akin to strict liability. If a misrepresentation was made, even if it was a mistake, it can still be found to have violated the World Bank's rules. Now, that is a very onerous standard, but it's designed because the bank recognizes that it has limitations on its ability to collect evidence.
Yeah, I will chime in here very quickly. I think about 80% of the charges involve fraud, and as a white collar practitioner outside of the development banks, my expectation of what fraud constitutes is that it is often heavily intent focused, and prosecutors and even civil authorities do not in many bodies charge fraud without some significant evidence that there was some sort of intent in terms of particularly a mistake that's been made. That has not been my experience at all in front of the development banks, that a mistake, as Matt said, can be viewed at least presumptively as fraud. And there is this almost strict liability where intent really becomes the burden of disproving intent as opposed to the development bank's burden of proving intent. The defendant or the respondent has some sort of duty almost, and the bank is looking for it to show that any mistake was innocent, as opposed to the fact that to essentially have some evidence showing that the mistake was intentional. Antonin, anything different in your view about the way that the banks apply some of these standards?
I definitely concur. And what is a bit frustrating when you're white collar lawyer and you're dealing with strict criminal concepts where normally you can't switch from one to the other, that when you're negotiating with the bank, it feels in a way like a sort of commercial negotiation where typically investigators will tell you that it looks like corruption, it might be fraud, and in any case, if it's not one, it's going to be the other. And you have a tendency, like you would do for prosecutors, that you have to pick, it can't be both or it can be one or the other. And in fact, for them, yes, it can. And it's possible that they will go for corruption theory. And if it doesn't work, they will fall back on fraud. Because at the end, even though the consequences are quasi-criminal, they're not a sovereign entity. So there's not the same concept of due process like the one we're dealing with in front of national jurisdictions. And they can definitely go for one theory, the other, or both. And that's not something that blocks them.
Yeah, to add to that, jurisdiction is based on contract, right? And so, essentially at the end of the day, the bank is deciding whether it wants to continue in a commercial relationship with the entity. Now, some banks, as we'll discuss, strive to have more of a quasi-judicial approach to those questions. Others might, in general terms, have commercial considerations when applying the sanctions process. But it's a commercial decision at the end of the day.
Yeah, I mean, the one other thing that I would add to that is, the obstruction cases as well look to me like the banks take a much different view than at least the U.S. criminal justice system, the U.S. civil investigative system in terms of obstruction. And what I mean by that is that as in outside of the bank system, the defense investigation can be very vigorous and often involves talking to some of the same witnesses contemporaneously with the bank investigators. I think that my experience is that the bank investigators, much more akin to some of the systems over in Europe, take a very dim view. They view it as almost trampling on the evidence in a way that in the U.S. system it's much more common to do those sorts of more aggressive defense investigations. So why don't we talk about some examples of sanctionable conduct in terms of fraud, corruption, and collusion, so we can give our audience a little bit better idea of what we're talking about in those areas.
Yeah, so to pick up first with the data, and Tim, you mentioned some of this already. I mean, World Bank does a good job in publishing data on each of these prohibited practices. If you look at 2017, 2018, 2019, between about 70 and 80% of cases involve fraud, about around 10 to 20% roughly involved collusion and corruption, and then a lesser percentage involved obstruction and coercion. You know, you can get a good sense of the type of conduct that is targeted by reviewing the sanctions board decisions of the World Bank or its digest, where it does good summaries. Here's a collection of matters we've experienced related to these areas. So it gives you a flavor for the type of conduct that companies really have to watch out for when they're participating in these projects in order to effectively manage liability.
Antonin, I know I heard you talk before about investigations starting as corruption investigations and then falling back to fraud investigations. Can you talk a little bit more about that and just kind of just provide some, like, a factual scenario in which that would occur, where the investigation starts as corruption and switches over to fraud? I think you're muted at this point.
Yeah, Antonin is muted. Maybe while you resolve that, I can jump in and, you know, give an example. I mean, the typical example is use of a third party, right? And the investigative authority. Oh, Antonin, go ahead. I'm sorry for jumping in.
I think, you know, no problem. It's sorry about that. So the typical context would be, for example, if the bank is looking for consideration and they won't be able to find it. So they suspect that there has been a trade-off and suspect there is corruption, but they won't be able to assess that. So in any case, usually they will go for misrepresentation in the context of the bidding, or improper contacts with the bank's people, or improper contacts with competitors, or improper contacts with quite anyone else. And even if they can't assess if there was a quid pro quo in the corruption scenario, they will switch angle and move to a different theory just in the middle of the investigation, which is obviously complex, and we'll turn to that in a few seconds, in building your defense theory and defense scenario. Because if the accusation is moving, it's obviously harder to know where to defend exactly.
Yeah, and the example I would add, Antonin, as well, is, you know, the investigating authority suspects that the company used a third-party agent to pay a bribe, and tries is unable to, you know, identify evidence of that bribe. So the fallback is, well, the company did not disclose in its bid document that it was going to use a third-party agent, and we have evidence that it used a third-party agent. We don't know what the agent was doing, but that's fraud. So that's an example of the fallback dynamic you're discussing.
And why don't we talk quickly about collusion, because I think a lot of the collusion cases have the same issue that we were talking about with fraud and corruption, where the standard of collusion often involves some sort of you know, proof of an agreement, whereas I think the examples that we've got on the slide are much more like no proof of an agreement other than some similarities in the bids. And so why don't you talk a little bit about that? First, maybe we'll start with Matt, and then we'll move over to Antonin.
Yeah, the collusion context is fascinating. You know, I participated in one of the first big successful collusion cases as an investigator and litigation specialist at INT. And and we'll be talking about standards of evidence in the next slide. But the point here is that it's circumstantial, right? It's multiple bidders having the same spelling mistakes in their bids, right? Or having similar patterns, unusual, hard to explain patterns of bid estimates on different products and inputs. So it's those sequencing, the patterns, the unexplained similarities that is going to, in the past, it would, what the authorities often required was also some statement by a witness or an individual to the effect of, oh yes, we coordinated. But now more and more, as the investigators are doing a good job in producing, hard to explain findings, now we've seen cases where those statements from witnesses are not deemed necessary.
Yeah, adding to that, it's in fact it's a quasi-competition issue we're dealing with when we're looking at collusion. Interestingly, basically the rationale behind the sanctionable conduct is that the market has been armed by an undue agreement among competitors, which allegedly diminished competition and therefore could have harmed the price or the quality of what was rendered. So it's unlike the corruption or fraud scenario, we're really looking at a quasi-pure competition issue here.
Interesting. So Matt mentioned that we're moving on to some of the standards. Why don't we talk a little bit about, I know that we've touched on this a little bit, but the standards of proof are not proof beyond a reasonable doubt, are they, Antonin?
No, they're not indeed, and it's preponderance of the evidence. So it's definitely a huge change, and that's obviously something that will count in negotiating with the bank. The rationale, as Matt was saying, is that the bank considers they have no power to investigate, so they have no subpoena, they can't search and seizure, and they can't make down raids. This could be discussed, however, when you see how easy it is to be in obstruction, but nonetheless, that is what they consider. Which means that when you negotiate with them, you normally tend to react, and that's how clients see it, as a preponderance of the evidence, like they don't have enough proofs, when in fact they do. It's more likely than not. So in a 50-50 scenario, how does it look like? That's basically the question the investigative body of the bank will ask you in knowing if you want to bring this case further and if you want to deny charges. If you look at the case I'm presenting to you after the investigation, is it more likely than not that the practice has been committed? And obviously, as you know, that is a very light test that the bank has to fulfill. And it changes a lot the way the investigation has to be conducted from the beginning and how your fact gathering process has to be conducted if you want to deny the allegations and you want to fight the charges that can be brought against your clients.
And Matt, I know you've had some experience where practitioners or respondents argue based on national laws, that is under the assumption that those are going to bind the World Bank. Can you talk a little bit about how the MDBs respond to those sorts of arguments?
Yeah, and so, I guess one way to put it is if you are a company that has legal representation and if those lawyers are crafting, the arguments before the MDBs and their lead off is, well, the national law of the country where the conduct took place is X, Y, and Z, to question the competency of your lawyers. This is the quick red flag for MDB, those involved on sanctions boards and committees or on first levels of review. These banks really see themselves as unique. They do not, I think that a lawyer who is leading off with national law is making a big mistake. And one thing it does is it sends a message to the reviewer at the bank that you don't perhaps appreciate the unique proceeding that is underway. Now, national law can be used, and we have used it in certain circumstances, right? If a respondent presents an analysis, for example, showing that legal systems in numerous different countries treat a particular legal issue the same, you know, with board members or committee members or first levels of review might find that persuasive. But really the focus should instead be what the banks have done in the past, reason, right? Does it make sense? You have to, the advice is to treat defense in the context of the multilateral development bank itself, and not, you know, go to try to reach outside of that, which is a normal instinct for you know, a lawyer barred in a specific jurisdiction.
Very good point. So I know that we have come to the end of the hour, but I think because of some of the technical difficulties that we've had, but as well because this discussion actually, you know, has a few more points to make. Why don't we continue on for about another 10 or 15 minutes? And if folks can stick around, that's great. And if not, we understand that this was originally scheduled for an hour. So why don't we talk a little bit about some of the sanctions, because we have talked about kind of the standards and what happens if various types of conduct get proven. But let's talk about if the World Bank or if the MDBs find that the conduct has been engaged in, what can they do to a company or to an individual?
I'm happy to jump in, Antonine. I mean,
sorry, I couldn't. I had problem with mute. So just in a nutshell, the slide is quite self-explanatory. The main issue is in fact a commercial one, because the main sanction that the bank can take is debarment. So the bank will cause the company or the individual not to work anymore with said bank and with the cross debarment with the other banks. So that means basically getting off the market on an important part of industrial projects throughout the world for the period of time that will be determined by the banks. That's all obviously the first set. It's the debarment, the first set of sanctions that can be imposed. The second one, and it's important to pinpoint that because usually that's the part which is the most sensible for clients, is the serious reputational effect that the sanction will have. As you probably know, sanctions from MDBs are sometimes and most often public. They are released on their websites, and it is something that your competitors, your clients and investors will look into. And obviously a sanction for corruption will have a stronger impact than just a debarment and will raise questions from stakeholders or from just your traditional banks. And those reputational effects can also, we've seen that in specific cases, trigger contractual consequences where a sanction with an MDB will create issue on the debt market or will obviously disrupt the way a company is normally working. And this reputational effect is sometimes, financially speaking, even harder than the debarment itself. Maybe Matt, I've talked about the debarment, which is some sort of the nuclear weapon that the bank is using. If you want to walk us through the intermediary steps that there are.
Sure. Tim, do you want to jump in and say something about the reputational effect?
Yeah, no, just very quickly. I will say that not only, you know, is the debarment sanction very, very harmful and creates reputational effect, but also those sorts of sanctions then go on to the various screening services that companies use, not only to find whether or not a company's been debarred, but whether or not they've been subject to sanctions such as OFAC sanctions or other sanctions from sanctions bodies around the world. And the debarment often will show up, which will create some confusion. So it's not just a reputational issue for the conduct itself, but it can have kind of collateral damage in terms of the reputation from various commercial screening services that we see all the time in my practice, where we're dealing with companies that are doing these screens, and they're coming to us to talk about what effect a debarment might have on a company outside just the pure banking system. And so it's not just the development banks, but it's also beyond that.
Great. Yeah, and just a couple of final points before we move on to the last slide. There is room to advocate on behalf of a respondent for other forms of sanction. For example, conditional non-debarment, where there's no debarment applied, or a letter of reprimand. And so there is movement. The bodies do recognize different forms of sanction given different levels, especially in so much of the battle during the briefing occurs on description, advocating, aggravating, and mitigating circumstances. So that will be a level of consideration. It's an area where some time should be placed in order to obtaining the best outcome.
Great. Well, why don't we move the reputational and from the reputational to the best practices and some of the lessons learned from our practice before some of the MDB.
Sure. Maybe I'll lead off here. So first and foremost, the most important advice is manage the compliance risk, right? And make sure that, if you're a company doing this type of work, that your compliance program is not just calibrated to address FCPA risk or UK Bribery Act risk, but that you are including the nuanced issues to address World Bank and multilateral development bank risks. Those guidance is found in the integrity compliance guidance published by the World Bank. The probably prominent example is, the company that has the mid-level employee who is charged with preparing the bid documents, wants to get the contract because his or her own success is based on that business, perhaps inflates the qualifications of their firm, and lo and behold, an investigation is launched years later. And the company says, well, we did not authorize that mid-level employee to do this. Well, that excuse doesn't work unless the company can show specific efforts to instruct that employee that, look, the bids need to be entirely accurate, they need to be thorough, they need to be defensible. If we are using third parties, we need to disclose them, we need to conduct due diligence on them, the company should be training its staff. It's those types of efforts that ultimately would give the company a defense in the case that it is brought into one of these investigations.
And Antonin, can you talk a little bit about how a compliance program of the type Matt's talking about can create evidence that you can use as the defense lawyer in one of these MDB proceedings?
Yes, of course. We can't emphasize enough on how important this is, and on each and every aspect, it will provide defense arguments, because a strong and robust compliance program, even though, for example, for fraud, intent is not a key concept, will provide elements to show that the company is, just to cut it short, a victim against a rogue employee. And this type of arguments, which are definitely strong, which can be strong, only will work if the compliance program meets the World Bank standard. Because if you have a weak compliance program, obviously you can't pretend that the company was not aware and has been trumped by the fraudulent conduct. So the strong compliance program will definitely provide a key defense element.
Yeah, and just to add a final point to that is, compliance is becoming more and more important to these bodies. We're seeing, as part of resolutions, the application of compliance monitors. And, if you do find a situation where a respondent did not perhaps have a compliance program in place at the time that the conduct occurred, it is certainly helpful as quickly as possible to undertake remedial measures to be able to show the authority that yes, the company gets it, and to the extent there was a mistake in the past, it's not going to happen again.
Right. It sounds like the better your compliance program is, the better you'll be protected against an investigation, and the worse that it is, the more trouble you're going to be in when the investigation starts. So what about this next bullet? So your company hears that an MDB is coming in for an audit after the project. Should you just assume that this is a routine audit as allowed by the contract, or what is the sort of audit that we're talking about here that is not necessarily an audit?
Well, I'm happy to jump in. This is the trap, right? This is where the company gets into trouble, and you can understand the dynamic. So a company has participated for years and years in a project that's financed by a multilateral development bank, and it's accustomed to interacting with those bank officials as part of the normal process. And then, all of a sudden it gets a formal notice saying that the bank wants to conduct an audit and might not fully appreciate the implications. And the implications can be that the bank has initiated an investigation, and the audit is its mechanism of gaining evidence, getting documents, interviewing individuals. So that is a very important educational point for companies participating in this world of business.
And I know we've had this experience in a number of cases. Antonin, how, as the lawyer coming in, how do you deal with the fact that your client may have participated in an audit before you even came on the case, and what are some of the problems with that?
Yeah, that's the biggest challenge, in fact, because everything happens, in fact, on day one. The moment you will collect the evidence, the moment you will transmit the mailboxes or fail to do so, is the moment your client will be either facing, for example, obstruction if the data collection has not been made properly, and if insufficient element was transmitted. We've seen that in the past, where we got cases where the response to the audit letter was clearly insufficient compared to the stake. So in reply to an audit, you have to take certain steps to freeze the data, to make sure that information is protected. And it's just not, as we have seen it, for example, just a few bundle of documents sent to DC for their review. That's clearly insufficient. And you can get definitely to obstruction for doing that. And also, I would say, and that's more maybe the white collar lawyer talking, but your defense strategy will get created from day one. So you need immediately to take the steps in order to protect your clients, to protect the company, and to launch the investigation in the best proper way to set the rules that will be going on for the 2 or 3 years that the investigation can last. You have to remember that it's not, as we said repeatedly, it's not a complete legal system. So you have no procedural rules, and some of the elements that will apply in the future will be set at the very beginning, and some of the rules that the bank and the company will apply can be discussed upfront. Timing of the interview, in person or through video, scope of documents to be transmitted. For European companies, protection on data protection and transmission of emails, those elements have to be discussed at the very beginning of the audit. And that's why it's indeed important to develop this strategy and set it up as soon as possible.
Otherwise, you can dig yourself a hole that you can't dig out of. And so I think, this next point ties right into that. Why don't you guys both talk a little bit about the importance of getting counsel involved early and formulating the strategy from day one, as opposed to winding up in a hole?
Yeah, I mean, the weakest cases we've seen are the ones where a record is already established when legal counsel gets involved, right? When there are interviews already conducted, when there are documents produced. Now, that doesn't mean to say having legal counsel means the company is not going to cooperate, but it means that the company will be careful in ensuring that what it's communicating has the right context, is accurate, is complete, is if not, what you're doing is essentially letting the bank, perform and develop its own investigation without any check to ensure that, what they're doing is accurate. One issue that we found is, when the legal counsel is retained, when we're retained late in the game, we don't even have access to the interview transcripts of the investigating authority until the accusation is made. So it makes it very hard to craft responses to the investigators, to prepare for a response to the accusation without knowing what our own people, the statements they made to the investigators. So this is perhaps the most important piece of advice: is reach out to competent lawyers early on in the process. That's a surefire way of positioning yourself to defeat these inquiries.
Yeah, one of the things we see is kind of this combination of the low legal standard and the mistake rule that constitutes either fraud or obstruction, combined with companies that get an audit request and in good faith really try to be very responsive, but these are people who their job is not to respond to the World Bank, and so they'll make mistakes, and they'll make mistakes in the responses because they're either going too fast or they don't know the whole story. And in my view, they're trying to be helpful, but those mistakes can turn into their own sorts of charges, as Antonin was talking about. I mean, do you have any horror stories, Antonin, about how late in the game people have talked to you and what sorts of issues that creates in terms of this hole that you've got to dig out of?
Yeah, we had a case where we got called in at the moment the company started negotiating the NRA. So we were at the level where the INT was offering a deal to the company in a negotiated agreement. So we did not conduct the investigation. We are not involved in the interviews, and we were only facing a document summarizing the charges according to the INT, and looking at the document, we really felt so it was a French client that took this, maybe I would say in a French way, where involving a lawyer is a thing you usually do when you come to trial and you're facing the judge. If you do that before, only guilty people take a lawyer initially, and innocent clients wouldn't do it in the French culture. And we've been dealing in a situation exactly as Matt was saying, having no clue on what was said, having no clue on what our own people who were interviewed had said, and having no clue at all on what was seized and analyzed in the documents. And looking at the NRA, we thought that the way the case was being presented, which I mean is fair, it's a negotiation, was a bit harsh, even unfair from the INTs. It took a very aggressive approach where elements of corruption, which were definitely not proven, were put not as allegation, but as proven fact when they were not. And also factors which could definitely diminish the sentence were not presented in a proper way. And taking the case so late in the process, at the moment of negotiating the NRA, well, you save what you can say, but you know you're not going to do miracles. And I still believe that the client they had a good case and they had elements they could definitely defend. And even though we were able to reduce the initial proposal to something that was more acceptable, I still strongly believe that if we became involved from day one, maybe we could have done much better than what was finally offered to the ANT. The thing that we can't assume that they work independently and in the global interest of the client. Even though they are independent from the bank, their mission is to preserve and to protect the bank's interest and the bank's funds. That's their only duty when they investigate. So they're not here for fairness. They're here to protect the bank assets. And if you keep that in mind, you know that they're not going to work for your clients, and they will only work in a way that will, according to them, best protect the bank.
So why don't we talk about this next best practice in terms of knowing what to expect during the proceedings? Now, we've talked a lot about that during this webinar, but I mean, what if you had an elevator speech, each of you, to sit down with a potential client that was going to be involved in the World Bank, what's the most important things that they need to know about these MDB proceedings?
Yeah, so I'll jump in the elevator first, Anton, and then you're right, Tim. First thing I'd say is watch the webinar. The second thing I would say is, you need to expect it's a sui generis process, right? This is a unique process. Second, long periods. It can be very frustrating for clients, but that's part of the game. So it's important for counsel to manage the expectations. Third, you're going to be dealing with very smart and prepared and competent folks on the other end. So I think those would be probably the key points. Maybe fourth, that start early with legal representation. It's counterintuitive for a company to think, okay, look, the bank is auditing us. They're asking for information we would have otherwise produced, documents and interviews. We have nothing to hide, right? Why should we be paying lawyers right now to come in and to hold our hands? But by not taking that step and getting legal representation, as we've said, and I just want to underscore it again, you are potentially unnecessarily creating additional risk for yourself.
If I had just an elevator speech, I think I would say that a World Bank investigation or MDB investigation is a bit like a Wagner opera. If you look at it like this, it can be long and it can be complex to understand. If you take some distance, it's very previsible. You know what is going to happen and you can anticipate exactly how it's going to unfold. You know how many acts there are going to be. You know how it is going to play and the steps that will be taken. And it's important to anticipate as much as possible, because they can't conduct raids, because they can't send subpoenas. It's hard to be surprised, in fact, and it's easier to know which next step is going to come. And those disruptive factors that you have in a criminal investigation, where clients can get arrested at the border, where you can get subpoena from the police, or where you can your offices can be searched, you don't have that in MDB's investigations. So you know that it's going to be document review, preparing for interviews, unfolding interviews, reviewing data in order to set your own narrative and be able to present that to the investigative body.
And we've talked about the different approaches, and I guess, is there something that just jumps out at either of you in terms of a different approach that one of the banks takes that you've got to be most wary of?
I think what I would highlight, and yes, we've talked about specific differences. Not every MDB is equal, but there are tone differences. You're dealing with the World Bank. The bank is striving to be quasi-judicial. It does, even though it doesn't formally honor precedent, it wants consistency. It does attempt to embed its decision-making in legal principles. Then on the other hand, with some of the regional MDBs, they're smaller, they're leaner, they're perhaps more commercially focused, perhaps less transparent about the decisions they make, and which gives them more room to make decisions based on a basic question of, is this the type of entity we want to continue doing work with or not? Those realities help shape defense, so they're important to take into account.
Any other thoughts, Antonin, on that bullet?
No, Matt made it clear. It's definitely true. We've seen that recently with African Development Bank. The main question they are, in fact, asking themselves is not, do we have a legal theory? It's more, is this a company with whom we want to work again in the future? So they are more acting like a bank than an investigator or legal body.
Which gets back to the compliance point that we made earlier, which is, the stronger you can show your compliance program is, the more likely it is that a bank is going to want to work with you going forward in the future. Now, there may be instances where they decide to make a point anyway, but it is, it's partly, you definitely don't want to get into a situation where your defense is, we made a lot of mistakes that didn't amount to fraud, because in that instance, you may be winning the case, but losing the war. So why don't we talk a little bit about how the facts really can win the case and the development of the facts can win the case. I think it ties into the early representation, but let's talk a little bit about how the facts can change depending upon what counsel is able to do and what counsel is able to look into.
Well, we're at a point now where, you know, these sanctions boards and committees have had a good 15 years of history under their belts, and during that time have heard pretty much every, you know, legal argument under the sun, creative and not so creative, right? And perhaps have begun to shape, you know, common responses. You see that when you review the decisions or you review the digest, which summarize prior sanctions board cases at the World Bank. So what that means is, you know, it's the facts where you win oftentimes. And like you say, that means getting the lawyers involved early. That means not just sitting back and relying on the investigative authority to do its work and then trying to respond to what it found, but it means showing context. It means showing detail. It means interviewing, you know, people or finding documents or looking at sets of emails rather than one email in isolation. That is the type of work that requires investment. And that's another pitfall we find with companies, is they're not willing to step up and make the investment necessary to develop that facts and to their detriment. Because without doing that, pulling the plug on that process really can damage the defense strategy.
Anthony, you want to talk about how cases are won on facts, or do you want to move on to the last slide?
Yeah, we can maybe move on to last. Maybe just one point, I'll start here. Settlements are indeed not always negotiated. There's one thing to keep in mind, and I'll just insist on that, and how those cases start off initially, and that gives you an idea of the margins that you have. Many World Bank cases or many MDB's cases start with another one throwing you under the bus. So it starts with a whistleblower, it starts with a competitor, somebody who lost a market, somebody who doesn't want you to win the next one, that will give you a name, tip off the investigators, and provide elements against your company. It can happen as part of a negotiation, and this is interesting because among the aggravating and diminishing factors that we have and that are on the paper, one element that also exists is giving more information about someone else to raise your own personal negotiation. And if the MDB has sufficient elements they got from someone else against you, well, they don't present you with a lot of settlement and a lot of room to negotiate. So they basically offer you a settlement which is not necessarily negotiated. It's more take it or leave it offer. Matt, maybe I think you have more elements about that.
I agree. I mean, it's not necessarily, you know, the equal bargaining positions, let's say. And so it's a case-by-case determination of whether a company wants to engage in these discussions. You know, what does the evidence look like? Do they want to just put this behind them? You know, the one opportunity I do think to get the authorities to move on debarment periods or level of sanction associated with the resolution is if you can, like you say, Antonine, offer up information about others. You know, they are interested in not only specific prohibited practices, but systemic integrity risk in certain operations, right? And so to the extent, you know, your company has knowledge, your client can help them root out that type of issue. You can have that work to your advantage in a resolution context. But you know, then there's also, we start off by talking about the potential for criminal referrals. You know, in a resolution, there needs to be some level of admission of wrongdoing, and you know, you're going to need to make those compliance upgrades we've discussed, and there has to be ongoing cooperation. So again, these are nuanced considerations. They're not easy for companies to make, that's for sure.
All right, well, why don't we go to each of you for the last word, since we're about an hour and a half in, and I think it's probably time to draw this to an end, but it's been a fun time talking to you all about this. I hope it was helpful to everyone out there, and I'm going to leave it to Matt and Antonin to make their closing arguments.
Well, thanks, Tim. I mean, what I'll say again is this is an area that's near and dear to my own heart. These banks are doing very important work. Companies working on bank finance projects are doing incredibly important work in challenging environments, especially in the COVID-19 era, right? Where it's the need for this type of work is heightened, but the risks are real, and education is real. We're at a point now where there's so many cases, and these investigative groups are so mature and developed and are out there doing a meaningful work that entities participating in these projects really do need to know the risks and the stakes and the expectations. If not, they can find themselves in a difficult place, which is, and we can tell you firsthand, extremely frustrating for a company that thinks it's doing good work in the development arena and then finds itself accused of misconduct as egregious as fraud, corruption, collusion, etc.
Antonin?
Yeah, just one quick word. So we know for sure that current investigations are paused given the current context, and to our knowledge, all MDBs have placed a hold on international travels and pending procedures. We however know, and we start receiving messages that they will start again their procedures and investigations in the coming weeks, and for sure we'll use the summer to prepare for September. So if you have the opportunity, you might look at the slides again during the summer because we can expect a start of investigations early September. Absolutely, it's coming soon to a place near you. And thanks everyone for to the panelists today, and thanks everyone on the webinar for your attention. We really appreciate it. Take care.